by the Every Student Succeeds Act of 2015. My name is Barbara Duffield. I am NECE's Director of Policy and Programs, and I am joined today by Patricia Julianell, NECE's Director of State Projects and Legal Affairs. Just a little bit of background for those of you who are not familiar with NECE. We are a national membership association dedicated to educational excellence for children and youth who are experiencing homelessness, and we work from early childhood through higher education. We have local homeless youth task forces across the country. Our Director of Higher Education runs our higher education program, including state higher education networks on homelessness and higher ed, and we have a very active early childhood committee. NECE is very much engaged in technical assistance on policy implementation, which is part of what we're doing today with this webinar. We also are involved in policy advocacy, bringing your voices to Congress and to state legislatures. And lastly, it's a very important part of our work. We work directly with young people, with young leaders, encouraging them to have their voices be heard in a very active part of the policy making and implementation process. Today what we're going to do is talk a little bit about the context and data around homelessness that underlie the amendments to in the Every Student Succeeds Act. We will look at the amendments for the implementers, the state coordinators and local liaisons. We will review changes that have been made to eligibility and identification. We'll look at changes to school of origin, immediate enrollment, disputes, Title I, and access to higher education. So that's a little bit of our agenda for this afternoon. Also, we are recording this webinar in case you have colleagues who you may wish to share it with later. And you do have in the materials folder there on the webinar, you do have a copy of this PowerPoint as well. We're going to go really quickly through some of the context here because we do have some late-breaking news that we want to share with you today. For those of you who are working with families and with youth who are on their own experiencing homelessness, these causes may be very familiar to you. Systemically and structurally, we're looking at a lack of affordable housing, coupled with deep poverty, changes in wages and employment that have really pulled the rug out from the poorest families and youth, health problems that contribute to homelessness, including addiction disorders and mental health, domestic violence as a significant contributor, natural and other disasters. And for homeless youth who are experiencing homelessness on their own, or unaccompanied homeless youth, there is a whole set of other factors, including abuse, neglect, and family dysfunction that we'll go over a little bit later. In terms of the prevalence and what we know about how many students are experiencing homelessness, the most recent data we have is from 2013-2014, and that school year it was a record 1.3 million students that's just identified and enrolled in schools. 7% increase over the previous year, 100% increase since the recession. And if you look at homelessness as a percentage of children living in poverty, it's 13% of all poor school-age children and 30% of all extremely poor school-age children and youth. So a growing number of children who are living in poverty and extreme poverty are likely to experience homelessness over the course of a year. Looking at some of the ages, we talked a little bit about unaccompanied homeless youth, but we will talk about some of the important ESSA amendments to early childhood. And this next slide here really sets the context for that. We know that over half of all children who are in HUD-funded shelters are under the age of 6, and that the age at which a person is most likely to be in a homeless shelter in the United States is infancy. It's actually under age 1. So the critical importance of reaching children in their early years in order to prevent problems later in life underlies a lot of the strengthening for early childhood that we see in ESSA. And lastly, you have the numbers for homeless kids who are children who are identified in public preschool programs. This is a relatively smaller number, in part because public preschool is not universal, nor is it compulsory. So we know we need to do a better job both increasing opportunities and also identifying young children who are experiencing homelessness. The impacts of homelessness on children and youth are well known. For those of you who access our Facebook page, I think that, I don't know if it was yesterday or today, Patricia posted an article, new research really looking at the lifetime impact of homelessness on children and youth, and both the moral cost as well as the economic cost to our society. So many of the statistics here on this slide are backed up by there's an article about Minnesota specifically that show these devastating impacts, everything from health and development to academic achievement, and also that we know that these gaps that occur early in a child's education can continue over time in their schooling, hence the urgency and the immediacy of the school outreach efforts and these educational protections. The barriers to education, also very well documented. Homelessness creates many, many challenges, from the very basic physical needs of being tired and sick and hungry and not having basic needs be met, to the emotional trauma, depression, and anxiety that go along with being uprooted and experiencing poverty. A lot of stereotypes around who experiences homelessness and why. We were just having an email exchange today with a liaison who was talking about how some of the school administrators are afraid that homeless children will lower their test scores, even though, of course, they're already in the school. So there's a lot of misconceptions about why people are homeless and what that actually means, and those misconceptions serve as a barrier to education. We know from many studies that children and youth who are homeless are underidentified, and that if they're not identified, then they cannot access the protections of McKinney-Vento. The high mobility, going from place to place to place, that also wreaks havoc with educational continuity and achievement. The enrollment requirements, things that make sense for a student with stable housing would not make sense for a student without stable housing and might actually pose a barrier to even getting in the door. Lack of transportation, also a challenge that we'll talk about, and lack of school supplies, clothing, and other basic needs. This brings us to our main topic today, the Every Student Succeeds Act of 2015. As I think everyone knows by now, this was passed by Congress and signed into law on December 10th of last year. And the Every Student Succeeds Act was the vehicle for amending the education subtitle of McKinney-Vento. It also amends Title I and other programs within the ESSA, within the Elementary and Secondary Education Act. In terms of effective dates, it took a little bit to get this straightened out due to some congressional snafus, but we know that the McKinney-Vento provisions, those amendments will take effect on October 1st of 2016. So October 1st of 2016 is the magic date for McKinney-Vento, with the exception of the deletion of awaiting foster care placement, which will be removed from the Act on December 10th, 1 year after enactment. We'll go over that in more detail. Title I and most of the other provisions in ESSA will go into effect for the 2017-2018 school year. And again, we'll cover that a little bit, but just to give you a sense of the timeline for the rollout of these amendments. I also want to talk a little bit about the difference between the statute and regulations and guidance. Many of you probably have seen lots of emails floating out about the Department of Education's regulations, proposed regulations, and guidance. So just a little bit of explanation here. The Department of Education, the abbreviation for which is ED, has the authority to issue regulations on parts of the Every Student Succeeds Act, including Title I. And what those regulations are supposed to do is interpret the gray areas of the statute and fill gaps. That's really the point of regulations. But regulations cannot conflict with what the actual law says. So the department does have limitations. It can't rewrite the legislation, for example, with its regulations. The department is required to publish its proposed regulations, its draft regulations, and it's required to consider public comments. And then once it's considered those public comments and it's finalized the regulations and published them in their final form, then they have the force of law. So they really are binding in a way, in the same way as the statute is. Also, the Department of Education has the authority to issue non-regulatory guidance on the Every Student Succeeds Act. We do expect such non-regulatory guidance on McKinney-Vento and also on most parts of Title I that apply to children and youth who are in foster care. And the guidance does not have the force of law. It is non-regulatory, non-binding, but it does indicate the Department of Education's interpretation of the statute. So we expect that we'll see that guidance shortly. The Department of Ed did just last week publish its proposed Title I regulations. It was published in the Federal Register on May 31st. We have already done an initial analysis of those regulations. There are several that pertain to children and youth who are homeless or in foster care and in foster care, including a few that are quite concerning to us, particularly around the transportation provisions for children and youth who are in foster care, which really do not which do conflict with the statute and which would really undermine a lot of the collaboration between school districts and child welfare agencies. So we wanted to let you know that that preliminary analysis and also a template for submitting comments are now available as of 15 minutes ago on our website. We strongly encourage people who are interested to submit comments. Again, the department does have to read them, and we've tried to make it easier for you by putting together a template that you can personalize and modify along with instructions for how you would submit those comments. They are due on August 1st of 2016, and we've provided, in addition to the template link, we've also provided a link to where you would submit the comments online. So again, this was not part of our originally programmed part of the webinar today, but given how urgent and important it is, we wanted to be sure to include it in today's webinar as well. So without further ado, we'll dig into the amendments to the McKinney-Vento Act. Again, those of you who have been working for this for a while, or even those of you who are new, this legislation has been around since 1987, was reauthorized very recently, works very much in collaboration with Title I and other federal education programs, and did receive a significant increase in the authorized funding levels. It was increased from $70 million to $85 million. That is still a teeny tiny, woefully inadequate amount of money given the scale of homelessness and given the requirements for McKinney-Vento, but it was the largest percentage increase of all the federal education programs in ESSA. So now it's been authorized. We await, in fact, today, the Senate Appropriations Subcommittee is marking up the 2017 budget, so we should know in a matter of hours or days what the Congress is thinking in terms of the actual funding level for next year for McKinney-Vento. The themes that we'll present the legislation to you today: identification, stability, enrollment, and support for academic success. And just as with the previous version of McKinney-Vento, our mantra is child-centered best interest decision-making, and that is even more true under this reauthorization of the law. So first we're going to start with the implementers, and you'll notice on these next slides that we have included the changes made by ESSA in this burnt orange or maroon or dark red color that you can see, whereas the current law, what is not changed, what remains the same, is in blue or navy blue text. So just to kind of highlight for you what's the same and what are the changes. Every state must designate a state coordinator for education for homeless children and youth, and the amendment here is the addition of state coordinator who can sufficiently carry out their duties. This is a recognition of the challenges that state coordinators have in terms of everything they're required to do and making sure that they are able, both in terms of time, authority, and training, to really be able to carry out those duties. There were, some added responsibilities to state coordinators. And as you look at these, just as with other parts of the statute, you may think, well, that's actually nothing new. My state coordinator does that, or I already do that. And just a reminder that many of these amendments, in fact, all of them, were really based on best practices, things that were going well that could benefit others, or where there were problems that were brought forth to us over and over and over again. So if you see this and think, well, this is already happening, I'm the state coordinator, I already do this, it's a validation. It's like, this is great, we recognize that, and now it's in the law and it's an expectation for every state. So some of those new responsibilities: conducting monitoring of local school districts, posting on the state education agency website an annually updated list of the liaison's contact information, as well as data on student homelessness, again to assist with transparency and communication that will need to be on the SEA website. The state coordinators have a new explicit duty to respond to inquiries from homeless parents and unaccompanied homeless youth to ensure that they receive the full protections of the law. Also, state coordinators must develop and implement professional development programs for liaisons and other school district personnel to help with the identification of homeless children and youth. And this training, this professional development, must include information on certain specified federal definitions of homelessness. So states must provide professional development, and it must include information on certain definitions of homelessness, including the HUD definition, and you'll see why that's important a little bit later on in the presentation here. Looking on at the local implementation of McKinney-Vento, we'll look at changes that were made to the role of local liaisons. Every school district is required to designate a McKinney-Vento liaison. Again, that's the same, but the change here, the addition has been that that liaison is able to carry out his or her legal duties. So again, a recognition that for many liaisons, it may just be not enough time, not the right person, lots of different reasons why the liaison may not be able to carry out his duties. Now it's an expectation that whoever the district designates must be able to carry out their duties. In terms of the actual duties themselves, you can see the ones that are the same, that have not actually changed. There's an addition of outreach to the identification responsibility for local liaisons. And I'll say here too that, again, particularly if you're new, the liaison is ensuring that these things happen. So that doesn't necessarily mean that it's only the liaison and the liaison is doing all of these things. They're ensuring that all of these things happen, and that means working collaboratively within the school system and also with the community. So it's much more of a coordination role than it is a job description per se. There were changes that were made to the public notice of McKinney-Vento rights, which have been required. So now the liaison must ensure that that notice is disseminated in locations that are frequented by parents, guardians, and unaccompanied youth in a manner and form that is understandable to them. So we may see some guidance, and I expect that we'll see some new resources from the National Center for Homeless Education in order to help school districts comply with this new public notice requirement. Other additions to the McKinney-Vento liaison responsibilities: ensuring that school personnel who are providing McKinney-Vento services receive professional development and other support. So just as state coordinators must provide professional development for liaisons, so too must liaisons provide professional development for school personnel. Additionally, there were some changes in terms of the liaison responsibilities for young children. Liaisons must ensure that children, youth, and families have access to receive the educational services that they're eligible for, including Head Start, early intervention, and other preschool programs. So the addition here is early intervention programs under IDA Part C, which were not specifically mentioned in the old version of the law, which are so very important, again, as we look at the devastating impact of trauma and poverty on young children, to really connect with those Part C programs, which may or may not be operated by the school district. So we envision that this will be, even in some of the bells and whistles, Cadillac McKinney-Vento programs, this piece may be a little bit new going into this next school year. A couple additions were made to the liaison requirement to ensure that homeless children, youth, and families receive healthcare, dental, mental health, and substance abuse and housing services were specifically added. Again, these may be things that liaisons are already doing, you've been doing for years. Now it's been made explicit, and if someone says, why are you doing this, you can point to the law and say it's right here in the law. And finally, as we look at the changes that were made to the McKinney-Vento liaison's responsibilities, we know that there's the continued duty around dispute resolution, but there's some specificity around that's new around unaccompanied homeless youth, that liaisons must ensure that unaccompanied homeless youth are enrolled in school and that procedures are implemented to identify and remove barriers that prevent them from credit for full or partial coursework satisfactorily completed at a prior school. We'll go over this in more detail a little bit later, but this is essentially a new requirement both for states and for school districts in terms of identifying and removing those barriers that prevent young people from getting the credit that they need to stay in school and to graduate from school. So there are some states that are ahead of the game on this, and we can look to them for models, but I think this will be another area going forward where, because it is so new, there'll be more work to dig into the implementation of this particular amendment. And then lastly, liaisons must participate in professional development and technical assistance as determined appropriate by the state coordinator. There's been an expectation, and most state coordinators have provided training over the past many years, but there has never been in the McKinney-Vento Act a requirement for liaisons to actually take part in that professional development. So now there is that requirement. This doesn't necessarily mean traveling to a conference in the state capitol or anywhere else. It could be a webinar, but the liaisons do have to participate in professional development as determined appropriate by the state coordinator. So that's another big and I think very important change. I'm going to switch a little bit now and talk about eligibility for McKinney-Vento. There were very few changes at all to this part of the legislation. So just a quick review. The definition of homeless in McKinney-Vento applies to all public schools. It is the same definition that is used by Head Start, by special education, by school meals. It's the umbrella definition of children and youth who lack a fixed, regular, and adequate nighttime residence. And then within that, some very specific categories: sharing the housing of others due to loss of housing, economic hardship, or a similar reason, which is the majority of students who are identified as McKinney-Vento, and it has been a growing proportion over the past few years. Also, children and youth who are living in motels, hotels, trailer parks, or camping grounds due to lack of adequate alternative accommodations. This is a smaller number, but proportionately it has grown over the years. And for both of these, you can see that it's context dependent. Due to loss of housing, economic hardship, or a similar reason, due to lack of adequate alternative accommodations. So those are very important parts of the definition of homelessness for school purposes. Other parts of the definition are perhaps a little bit more obvious: living in emergency or transitional shelters, other places that are not meant for people to live, cars, parks, etc., children who are migratory children who are living in those circumstances. And then we'll get into this a little bit later in more detail, but awaiting foster care placement, that designation under the definition of homelessness is removed from the law on December 10th, 2016. And again, that's 1 year after enactment, and a whole other set of protections for all children in foster care go into place. So there's a change in the way that federal education law will respond to the educational needs of all children and youth who are in foster care. A little bit of context for this definition. This is, I think, more for people you may be training who may say, wow, that seems like it's a pretty broad definition. It's important to remember that shelters don't exist in many suburban and rural areas, and even if they do exist, they're often full and have waiting lists or turn people away. Many shelters have rules that will restrict them, will restrict eligibility. So for example, boys over the age of 10 or 12 or unaccompanied minors won't be allowed to stay there. So sometimes the eligibility for shelters means that families or youth are not eligible. We know for sure that young people who are homeless on their own, our unaccompanied youth, are very afraid of adult shelters and won't even show up to a shelter because of things that have happened to them in their past, and so they're not likely to show up to an adult shelter and may end up in other situations. And shelters may have time limits on how long you can stay there. So even if somebody was able to get in, there was space, they were eligible, they may not be able to go back. And for many families, motels may not be available, or they may be expensive or unsafe. Unfortunately, many motels are have a lot of drug activity, a lot of trafficking and registered sex offenders there, so motels may not be a safe option for families. They may be their only option, but they are often not safe. And then just lastly, to keep in mind that many families and youth don't know what their alternatives are. They don't have time to take out their smartphone and Google homeless shelter in the area, so they land where they land, and that may not be a good place. To look a little bit now at our definition of unaccompanied homeless youth, a couple changes that were made by ESSA here. The definition of an unaccompanied homeless youth is a child or youth who meets the McKinney-Vento definition and is not in the physical custody of a parent or guardian. So there had been some confusion around, can you have unaccompanied youth under McKinney who are not homeless? And the answer was always no, and now it's been made clear that in order to be eligible for McKinney-Vento, you have to meet the definition of homeless. And then there are additional requirements if you both meet that definition and you're not in the physical custody of a parent or guardian. And we've summarized here some of the specific research on why young people may be on their own and experiencing homelessness due to shelter policies, abuse and neglect are the primary reasons, identification as LGBT, and a lot of kids kicked out of their homes because they're pregnant or parenting. So just some context here. And at the end of the PowerPoint, you have some citations for this research in case you'd like to use it in your own trainings that you do. When we are applying, determining eligibility under McKinney-Vento, nothing has changed here with reauthorization. It's always case by case. You're always getting as much information as possible with sensitivity and discretion, understanding that this is hard information to talk about, it's hard information to share. You'll first look at the definition, look at those specific examples first and the overall definition, and then consider how you might sensitively ask questions about particularly families and youth who are staying with other people. For example, where would you go if you couldn't stay here, or what led you into this situation? Those can be helpful questions to figure out, is this a situation that meets McKinney-Vento or not? And there's a great resource for you on the National Center for Homeless Education, a link there about determining eligibility. So feel free to download that as well. And again, I'm sure NCHE will be updating all of their materials to respond to the changes in the McKinney-Vento Act. All right, I'm going to skip the strategies here. We have a lot to go over, and you probably already noticed that we have the presentation that you have that I've already skipped some slides. We have lots of strategies here that have been developed by school districts and communities over the course of the years, and we just want you to have those as you move forward in implementation, but we don't necessarily need to talk about them. So I'm going to pause now, and I'm going to turn it over to Patricia, who will talk about some of these next slides around school stability, enrollment, and support for academic success.
Thanks, Barbara, and good afternoon or good morning to everyone on the call. Thanks for being with us today. Barbara has done a great job covering the who under McKinney-Vento in terms of state coordinators, liaisons, and the students themselves. Now we're going to move into the what in terms of the actual rights and protections under the McKinney-Vento Act. We probably don't need to share with any of you the research on school stability or why school stability is important. I think that's pretty common knowledge at this point, and it's really the focus of the McKinney-Vento Act is trying to help students stay stable even though homelessness may be forcing them to move around. So that's where we get into our McKinney-Vento Act provisions on school stability. And the basic school stability functions of the McKinney-Vento Act really haven't changed. You'll see on upcoming slides some new language that has been added. Most of that language has been in Department of Education guidance for over a decade. So most of it will not really seem new to you or change any of your procedures, but we'll tell you the parts that are new. As always, each LEA has to look at each student's best interest and make a determination to either continue that student's education in the school of origin for the duration of homelessness and also to complete the academic year when they find permanent housing, or to enroll that student in a local public school, or any public school that house students living in the same area would be eligible to attend. What we do have in ESSA, however, is a change in the definition of school of origin, and this is a pretty big change. So school of origin always has been defined as the school attended when permanently housed or the school in which the student was last enrolled. Two amendments to that definition under ESSA. First of all, school of origin now explicitly includes a preschool. So a student who is in a preschool program, a 4-year-old who's attending, and then in November they lose their housing and they move to a different attendance area or even a different school district, now has the right to remain in the preschool of origin to complete the school year, and if it's a multi-year preschool for the duration of homelessness. Of course, that's going to be subject to best interest, just like all of our school of origin determinations are. The other change to the definition of school of origin has to do with feeder schools. So if you are in an area that has designated feeder school patterns where all of the students automatically feed into a designated receiving school, so if they complete 6th grade at McKinney Elementary, all the students automatically filter into Vento Middle School, that is their designated receiving school, then McKinney-Vento students also will be able to follow that flow of students in the feeder school pattern, and again, assuming that that is in their best interest to move from 6th to 7th or 8th to 9th according to that feeder school pattern. The best interest determination process probably isn't any different than what you've been doing, because this is where that Department of Education guidance has been moved into the statute. So as always, we are presuming that staying in the school of origin is in the student's best interest. We always want to err on the side of stability, unless that's contrary to the parent's, guardian, or youth's wishes. We're always going to consider student-centered factors, including the impact of mobility on achievement, health, and safety. Some of those factors you can imagine are going to weigh differently if you're looking at a preschool child than if you're looking at a 17-year-old trying to finish their senior year in high school. So as always, it's going to be student-centered. As always, there is priority for the parents' or guardian's request, but again, it is a best interest determination that the school district must go through. And now we do have a change that in addition to giving priority to the parents' or guardian's request, school districts also must give priority to the youth's requests in a case of an unaccompanied youth. So under current law, the McKinney-Vento Act requires liaisons to consider the wishes of the youth. The ESSA now changes that to say give priority to the youth's wishes for unaccompanied youth. I think that's significant because sometimes when schools are in a situation where a youth is asking for one school, but there may be a parent out there who calls in and says, no, 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 we want something else. And when working with unaccompanied youth, schools find themselves in a bit of a conundrum about what to do there. I think the new ESSA language really gives schools that additional support federally to say, you know, under McKinney-Vento Act, we really have to give priority to the youth's requests when we're working with unaccompanied youth. Now, if the LEA or school district determines that it's not in the student's best interest to stay in the school of origin or to attend the school that the parent, guardian, or youth has requested, then as always, you have to provide a written explanation of that. That explanation must include information for how the student or parent can appeal if they would like to do that. And new under ESSA, that explanation has to be in a manner and form understandable to the parent, guardian, or unaccompanied youth. So to let them know really why that decision was made and how they can appeal it if they wish to do so. In terms of transportation, transportation to and from the school of origin is required as it is under current law. There is a clarification, though, under ESSA. It's been a little bit of a gray area in the law about whether transportation was required for a student attending their school of origin after they moved into permanent housing. Some states were doing that, some states were not. Under ESSA, that's really clarified to say that transportation is required for as long as that student is attending the school of origin. So if they find permanent housing and it is in their best interest to complete the school year in their school of origin, then transportation will be required for that period of time. The cost sharing provisions haven't changed. That would be really up to the LEAs to decide how to share those costs if the student's crossing school lines, or if they can't come to a decision, then to just split it 50-50. There really aren't any changes in other transportation provisions. Other transportation continues to be comparable for students who are experiencing homelessness to those who are not. And also the requirement for LEAs to eliminate barriers to enrollment and retention. And sometimes those barriers can be related to transportation. So looking at policies to try to eliminate transportation barriers to full participation. So that could include extracurricular activities as well. And we'll come back to this particular requirement a little bit later as well, talk a little bit more about it. So we're going to skip transportation strategies and instead get to enrollment. So we covered the issue of school stability and trying to keep students in their school of origin, but of course there are always situations where the school of origin is not going to be in the student's best interest, or it's simply not what the student or the parents want. And in that case, our McKinney-Vento students are entitled to immediate enrollment in any public school that students living in the same area are eligible to attend. So obviously that's going to include the neighborhood school, the attendance area school. There might also be magnet schools or charter schools or alternative education programs that also are available, depending on what is out there in your community and your school district. That enrollment, of course, is immediate, even if the student does not have documents that are typically required. That's always been the case under McKinney-Vento. ESSA does a little bit of playing with the language here to specify that this includes if the student doesn't have immunizations or other required health records. I think that language was just broadened a little bit to recognize other document requirements related to health, such as TB tests or allergy plans, or for the EpiPen or for peanut allergies, et cetera, to make clear that enrollment needs to be immediate in those situations. And then, of course, we have to work on the health records as quickly as possible. One last change there to immediate enrollment is that students also have the right to immediate enrollment even if they've missed application or enrollment deadlines during any period of homelessness. So for the most part, we're looking at probably charter schools or magnet schools, other specialized educational opportunities that actually have applications that oftentimes might happen in the fall or in the spring before the next school year. So students who miss those application deadlines during a period of homelessness, if the school is full, then it's full. There's not much we can do about that capacity issue. But if the only thing keeping the student out of a particular school or school program is that they miss an application deadline, those deadlines would need to be waived for McKinney-Vento students. The definition of enroll and enrollment those definitions have not changed. So as we know, that includes attending classes and participating fully in school activities. And then here's that barrier removal language that I said we would come back to. Both states and local educational agencies must review and revise their policies to remove barriers to identification, enrollment, and retention of McKinney-Vento students in school. So you can see the addition of identification there, and you can think about what might be barriers to identification in your district. It might be the way language is used on some of your enrollment forms. It might be that you haven't been able to have adequate residency questionnaires or other forms available to help with identification. So really taking a broad look at how identification is being done in your district, what policy barriers might be in place, and how can those be fixed so that they're not barriers to your work any longer. And you can also see a specific inclusion at the very end there to include barriers due to outstanding fees or fines or absences. This is really just a clarification. I don't think it's anything new, but oftentimes we get questions about, for example, students not being allowed to take out library books because she has some unpaid library fines from a previous school, or not being able to participate in graduation because of unpaid fines. Those barriers that are related to fees or fines or excessive absences, they do need to be waived or addressed if they're restricting the student's full participation in school activities. Not much change on immunizations. I think we already talked about that. And of course, enrolling schools must obtain school records from the previous school. Even though we require immediate enrollment, there's always the importance of trying to get records, trying to get that paperwork and information. We know that that's important for students to make sure that their academic program's correct and that their health and other issues are being addressed. And we'll skip over this strategy slide again. In terms of unaccompanied youth, as always, all of our immediate enrollment and school stability provisions apply to unaccompanied youth just as they would apply to other students. The only real change under ESSA here is the one I mentioned earlier about giving priority to the youth's wishes when looking at school of origin versus local school enrollment for unaccompanied youth. Enrollment in preschool. There are a couple of preschool changes here. I'm going to start from the bottom actually and work up on this slide. Barbara already mentioned the importance of collaboration with early intervention programs for young children with developmental delays. And I talked about the inclusion of preschools in the definition of school of origin. That's certainly a significant change. The other thing I want to point out is actually not something that's there, but something that's not there. So in that first bullet, there's a word that ESSA removes, a couple of words actually. The bullet that you see there is the ESSA language. State McKinney-Vento plans must describe procedures that ensure that homeless children have access to public preschool programs administered by the SEA or LEA. There's a couple of words missing there. Under current law, it says state McKinney-Vento plans must describe procedures that ensure that homeless children have equal access. That word equal has been removed by ESSA. Now we'll have to see if we get guidance from the Department of Education about exactly what that means, but it certainly means something when Congress amends a statute in that way. It seems to me that it probably means we need to do something more than equal, since young children experiencing homelessness have more than equal challenges in accessing preschool. states and LEAs can do more than equal measures to try to make sure that they have access to those programs. So that might be addressing transportation barriers, it might be addressing enrollment and mobility barriers, et cetera, to make sure that students can access those programs. Even things like holding slots available so that students don't get stuck on that endless waiting list as they move from community to community. Dispute resolution, there are a couple of new pieces of ESSA about dispute resolution and also about avoiding disputes. So just quickly, really any dispute that takes place under the McKinney-Vento Act's rules and rights should be addressed under the McKinney-Vento Act's dispute procedure. I think that just makes sense. So disputes that arise over eligibility, school selection, enrollment, etc., fall under the McKinney-Vento dispute process. As always, the student is enrolled immediately in the school in which enrollment is sought, pending final resolution of the dispute, so all appeals that are available within your state system. Schools must provide, like I said before, that written explanation of decisions that are made at the school level as well as at the school district or state level, and then refer that parent, guardian, or youth to the liaison to assist them in understanding the decision and, if they wish, in filing an appeal on that decision. There are also quite a few pieces, I think, that can help avoid disputes, so we don't even get to this dispute resolution procedure. Certainly the new requirements on training should help. The new requirements on making sure that liaisons have adequate capacity to be able to complete their duties hopefully will help. Also the requirement that states monitor LEAs hopefully will help districts be prepared and kind of know what they're doing well and what they're doing not so well before a dispute arises. And then the importance of making sure that our policies address barriers and facilitate good implementation of McKinney-Vento at the local level. Pop quiz. We do have pop quizzes on our website for when you're doing your own professional development in your district or in your state. You can go to our website and download PowerPoints and the pop quizzes, etc. But for now, I think I will turn it over to Barbara to talk about support for academic success.
Thanks, Patricia. So just a couple of pieces here that are new. Requirements for states to have procedures to eliminate barriers to academic and extracurricular, excuse me, I'm missing this piece of the slide there is covered by the screen. Whoops, sorry about that. To remove barriers and ensure participation in academic and extracurricular activities, including summer school, career and technical placement, online learning, and other programs that are available. So this, we've had for a while our definition of enroll, meaning attending classes and participating fully in school activities, and now we have some more specificity in the legislation requiring procedures to eliminate barriers for both academic and extracurricular activities. And then here too is that in the next bullet is what we referenced in the local liaison responsibilities, that states must have procedures to identify and remove barriers that prevent youth from receiving credit for full or partial coursework satisfactorily completed. And again, as we've already mentioned, those are some states have enacted state laws that go towards this. You can look on our website and see some examples from California and Texas. And this is definitely something that will have to be both a state level responsibility as well as local liaisons who will be implementing these procedures. Looking now to some of the pieces in the McKinney-Vento amendments for supporting the transition to higher education. There is a brand new requirement that all McKinney-Vento youth must be able to receive assistance from counselors to advise students and prepare them and improve their readiness for college. So that engagement of school counselors is new and also is part of the state plan in the ESSA amendments. And then the liaison requirement. Liaisons now must ensure that unaccompanied homeless youth are informed of their status as independent students and that they may obtain assistance from the liaison in the verification of that status. We know that many of our unaccompanied homeless youth may have discounted college and think that college isn't something that they could do, particularly without the support of parents. So ESSA now says that liaisons need to let students know, unaccompanied homeless youth know that they are able to go to college and get financial aid as an independent student, and also help them get the assistance from the liaison in the verification of that status. Additional pieces around coordination for academic support. There's provisions around coordinating McKinney-Vento services with special education services, both within the school district and with other involved school districts. There are, I guess, a clarification in McKinney-Vento that information about a McKinney-Vento student's living situation is a student record and is therefore protected by FERPA. So the school districts cannot release that information to people who are not authorized to have it, which has been the case, but is now again explicit in the law. And lastly, a brand new piece that local liaisons are authorized to affirm that children and youth meet the definition of HUD homeless assistance programs in order to qualify them for HUD homeless assistance. So this one's a little bit perhaps not self-explanatory, so I'll take a little bit longer to explain it. This does not actually change the HUD definition of homeless. That's still an ongoing conversation, it's still an ongoing legislative campaign to change the HUD definition of homeless. But what this does do is say that rather than the family or the HUD provider having to prove that the youth meets the conditions of HUD's definition, the liaison is authorized to affirm that they meet that definition. So if the liaison has had training from the state about the different definitions of homelessness, they can affirm, yes, this child meets the definition of HUD's homeless assistance program and is therefore eligible. This is perhaps going to be the most useful for some of those categories of the HUD definition that are right now not very clear. For example, youth who are staying with other people and can only stay there for 14 days or less and have nowhere else to go. Under HUD's rules, that's considered imminent risk, and you're technically qualified for HUD's homeless assistance. But under HUD's rules, either the youth or the provider has to prove that that person can only stay there for less than 14 days, has no networks, has nowhere else to go. And these are things that are either impossible for the youth or the family to prove, or way too much work for the HUD provider to prove, but liaisons will know the youth situation, may know the youth situation, and may be able to say, yes, this is definitely the situation, and provide to that HUD homeless assistance program a piece of paper in the same way that liaisons are verifying unaccompanied homeless youth for FAFSA or verifying homeless children and youth for free school meals to work in exactly the same way. We do anticipate that this is an area where federal guidance will be necessary because it involves two agencies, and HUD homeless assistance programs are going to need to get the same information that local liaisons get about how this new provision will work. And again, the entire point of it here is to expedite referrals, streamline the process, and not have the burden of paperwork fall upon either the family, youth, or the HUD homeless assistance provider, who may not be inclined or have the time to really know those things that a liaison would already know. In terms of other pieces for academic support, the National School Lunch, nothing has changed here. McKinney-Vento students are still automatically eligible for free school meals. The policies for doing that are the same. So again, in case you're new and didn't know that, we include that slide as well as some helpful links for more resources. Charter schools, there's another part of ESSA, the Title IV of ESSA, that pertains to charter school grants, and again, this will be starting in 2017-2018, that states receiving charter school grants need to work with charter schools on recruitment and enrollment practices for the inclusion of all students, particularly eliminating any barriers to enrollment for foster youth and for unaccompanied homeless youth. So we'll have some new McKinney-Vento-esque like provisions applying to charter schools starting in the 2017-2018 school year. We're going to turn now, or the last part of our presentation is looking at Title I, Part A, and those amendments. These amendments, with one exception, these amendments will go into effect for 2017-2018. There are some things that are changed and some things that are new. McKinney-Vento students are still eligible for Title I Part A services, no matter what school they go to within the school district. There's a new provision that state report cards must disaggregate achievement in high school graduation data for both McKinney-Vento students and for students in foster care. This provision, again, is new for 2017-2018. Many states already have this information or are able to get it for homeless students, but just haven't been able to require to actually calculate it and publish it. Now they will be able to do that. Within the local Title I plans, those plans must be coordinated with McKinney-Vento. The local Title I plans need to describe the services provided to McKinney-Vento students, including with the set-aside funds, to support their enrollment, attendance, and success. And again, the last part of the provision there in the red text is what is new in ESSA. In terms of the Title I set-aside, the reservation of funds under Title I Part A, all school districts that receive Title I-A funds must set aside funds necessary to provide homeless children and youth with services comparable to children in Title I-A schools. The change here is in the previous version of the law said to support homeless children attending non-participating schools, meaning that technically only school districts that had non-participating schools were required to do a set-aside, which meant that some of the highest poverty school districts, the ones that are all school-wide programs, were not technically required to do a set-aside. That part of the law has changed, and it is clear now that all school districts that receive Title I-A funds, including those that are all Title I schools, must set aside funds to support homeless students. ESSA specifies that the amount of that homeless set-aside must be based on the total LEA allocation prior to expenditures or transfers, and that it may be determined based on a needs assessment. So the law says such sums as may be necessary, but then goes on to say that that amount needs to, really should be, maybe determined based on a needs assessment and should involve the liaison. That last part is in italics because it's not part of the law. It's part of the department's guidance that we expect to continue on with the ESSA implementation. Also, the expectation, the same as previous, that the amount is sufficient to provide comparable services to homeless students regardless of other services that are provided with the reserved funds. The use of Title I funds, there's been some pieces here that are, I would call, not so much clarified as codified, put into the statute. For the past several years, because of the budget, Title I funds have been allowed to be used for services not ordinarily provided to other students, including funding the homeless liaison and including providing transportation to the school of origin. Those were changes that Congress made as part of the budget process. Now, however, those are changes that have been made to Title I in the underlying statute. So we're not dependent on, is this going to be the same with this budget bill or not? This is now in the law, the continuation of that policy that Title I Part A funds can be used for the liaison, transportation to the school of origin, and again, for services that aren't ordinarily provided to other Title I students. I'm not going to go over these next couple of slides here that look at the permissible uses. You have them in your PowerPoint. These are the same. These are from the Department of Education's guidance, and you can see there's a wide range of activities that you can use the Title I funds for. The guiding principles, however, to make sure that services must be reasonable and necessary to enable homeless students to take advantage of educational opportunities, and also that they're used as a last resort when services are not reasonably available from another public or private source. So in other words, if a child needs a pair of shoes to participate in gym class and you have already a clothing closet that you can get the shoes from or some other resource, that would be the first place you go to. But if there is no other place and the child still needs a pair of shoes, you're not expected to knock on the door of every faith-based organization or civic organization. You can use the Title I Part A funds for that so that the child can take part in educational opportunities. Real quick on the FAFSA, there's been no change here. We hope that there will be, and you can look at our website under legislative updates for some pretty exciting legislation for higher ed for foster youth and homeless youth, but the FAFSA provisions were not changed by ESSA, so we just have this slide in here as a reminder about who can make the determinations. So again, there was a report from the GAO done a couple weeks ago. Encourage you to look at the news part of our website so you can see what that GAO report found, as well as some of the legislation that we are very excited about. But for the time being, nothing changes with respect to the FAFSA and unaccompanied homeless youth or foster youth. Here would be a pop quiz number two. Would you be doing this in a different setting and not on a webinar? So you can find that on our website. And the very last piece of the presentation today before we go to questions is to look at the changes that were made for children and youth who are in foster care by Title I Part A. So this slide here is the short version. Essentially, ESSA creates new assurances that provide all children in any stage of foster care with protections that are similar to McKinney-Vento, but it doesn't provide them through McKinney-Vento. It's through Title I Part A assurances. With respect to transportation, school districts are not required to provide school of origin transportation if there are additional costs, unless they are reimbursed by child welfare or unless they agree to provide it. That's what the law says. We'll talk about that in a second. And again, the removal of awaiting foster care placement from McKinney-Vento 1 year after enactment. The emphasis here and the rationale is that while children and youth in foster care have the same needs for access and stability, there is a big difference between children and youth who are experiencing homelessness and those who are in foster care, and that is the presence of another agency that is funded and is legally responsible for their well-being, basic needs and well-being, including educational stability. So we know that we need to have reciprocity between child welfare and schools, but we also know that unlike for children and youth who are homeless, there is another agency who can partner with school districts to ensure that children and youth in foster care have the stability that they need to do well in school and graduate. So just a little bit more here. I see we're getting late on time here, but in terms of the Title I provisions for school stability, state Title I plans need to describe their collaboration with the state child welfare agency to ensure educational stability, ensuring that foster youth can remain in their school of origin, and that as long as it's the determination made that it's foster youth remain in their school of origin unless it's not in their best interest, unless a determination has been made that it's not in their best interest, and when a determination is made that it's not in their best interest, that they are immediately enrolled in a new school. So again, very McKinney-Vento-esque protections for all kids in foster care. The state education agency has to designate a point of contact for child welfare agencies. That person will oversee the implementation of the state agency responsibilities, but that person cannot be the same person as the McKinney-Vento state coordinator. So there's a distinction there, a separation of roles. It's going to be a big job for both the foster care state coordinator and for the McKinney-Vento state coordinator. They have a lot on their plates. Looking at the local Title I plan, local Title I plans must contain an assurance that the LEA will collaborate with the state or local child welfare agency, including designating a point of contact if the corresponding child welfare agency notifies the school district in writing that it has designated a point of contact for the school district. Anticipating that you may be asking, well, is there a prohibition on the homeless liaison being the point of contact for the foster care liaison? No, there is not that prohibition, but a reminder that McKinney-Vento requires that the liaison be able to carry out their duties. And in some districts with high numbers of foster youth or high numbers of homeless youth, they will not be able to carry out their duties if in fact it is the same person. So that is the guardrails on that particular provision. And very lastly, with respect to transportation, within 1 year of enactment, that means December 10th, 2016, the same day that awaiting foster care placement is deleted from McKinney-Vento, is the same day that local transportation procedures for foster care must be in place. And here what you have is actually the language of the law. You will know that this is not what the department put forth in their regulations, which is why we're asking for people to comment with their own experiences. But the legislation is very clear that there must be procedures, local procedures that are developed and implemented by December 10th, and that they will describe how children and youth, that they must be done in collaboration with child welfare. They must describe how transportation will be provided, arranged, and funded, that the foster youth who need transportation receive it in a cost-effective manner and in accordance with the Child Welfare Agency's authority to use child welfare funding under 4E of the Social Security Act, and that if there are additional costs incurred in providing transportation to the school of origin, school districts will provide it if they're reimbursed by child welfare, if they agree to pay the costs, or if the school district and the child welfare agency agree to share the costs. Again, this comes straight from the law. So that is also part of the local transportation procedures, which will need to be in effect by December 10th this year. I want to stop here because we went a little bit longer. I think we had extra information about the regulations that we didn't expect. You have resources here, but I want to stop and see, Patricia, if there are any questions that we can take at this time.
Yeah, Barbara, there are. I've answered quite a few of them in the chat box. And I did answer this question, but I'd like you to talk about it anyway. It's about the definition of preschool under McKinney-Vento. I did say in the chat box that there is no definition in the statute, and I talked a little bit about what we may get from the Department of Education on that. But would you just weigh in a little bit about what the definition of preschool might be?
Well, the only clue that we have right now is that the Department of Education did define public preschool for data collection for homeless students. So if you go on NCHE's website and you download NCHE's Guide to Data Collection, you'll see what they had put forth as a definition for public preschool programs. And essentially it is preschool programs 0 to 5 that are administered by school districts. And Patricia, please jump in with any of the nuances here. So it gives some specific examples of what those might be, but we're highly unlikely that the Department of Education will issue guidance defining preschool to mean community-based preschools that are not operated by school districts. I think the real question is, for example, will the department define Head Start programs that are administered by school districts as preschool programs? But I think we're fairly confident right now, or at least our best guess probably is a better way to say it. Our best guess is that the department, if they define preschool in their guidance, that it will be limited to preschool programs administered or funded by school districts.
Thank you, Barbara. We had also a few different questions about the feeder school issue. And I guess if you could talk a little bit about, one easy one is if students are going to continue to attend their feeder school as their school of origin, is transportation required?
So the short answer to that is yes. The transportation provisions, again, everything's subject to best interest. So if it's in the best interest for a child to continue in their school of origin, feeder school, school of origin, if it's in their best interest, then transportation would be required per any other school of origin.
Great. And then there's another one that maybe I'll try to tackle about feeder schools, particularly in the preschool context. And I think this takes this takes two complicated things and puts them together and makes one great big giant complicated thing. So really figuring out what is a feeder school pattern and a designated feeder school is one question. So looking at your own district, if there are multiple feeder schools, the question is going to be, is that a designated feeder school pattern? In other words, if students are placed in the next school based on their address, that's not really a feeder school. That's really an attendance area school. And so it probably would not meet that definition of school of origin as feeder schools. But if there are multiple feeder schools that really are not address dependent, but it's just for whatever reason, there's an elementary school that could feed into two different middle schools, and there are different criteria that the district's looking at to determine who goes into which middle school, then McKinney-Vento students would be able to follow that feeder school pattern the same way that other schools follow that feeder school pattern. For preschools, the question will be, is there, again, truly a feeder school pattern from a preschool into an elementary school? We know that a lot of preschool programs really aren't neighborhood schools the way we would think of it. Sometimes they're open to anyone in the district, regardless of where they live. Sometimes they're open to anyone, even if they live out of district. And what happens is the child will complete a preschool program, and then they'll go to elementary school really based on their address and not based on any kind of feeder school pattern. So again, if the assignment to the school is address-based, that's not really a feeder school, and so you would not look at that as a school of origin. So hopefully that helps clarify that question a little bit. One other question, Barbara, could you talk a little bit about when a barrier to an extracurricular activity is transportation? Is that a flat-out requirement to provide transportation, or how does transportation work in the case of an extracurricular? So not a school of origin, but some kind of an extracurricular or other activity.
There isn't a flat-out requirement for transportation to extracurricular activities in the same way that there is for school of origin transportation. So maybe that's the first thing to say. The second thing to say is that we're looking at the provision about removing barriers. So what would it be to remove a barrier that is a transportation barrier for extracurricular activities? That might not necessarily mean a bus. It may be other ways that a transportation barrier for extracurricular activity could be removed. But so that's going to be depending on the situation. And I don't know, Patricia, if you have anything else to add to that nuanced area.
No, I don't think so. Um, I think that's what I would have said also. I'm just skimming through here quickly to see if there are any other questions that we haven't addressed. Maybe we can give people maybe an additional minute to submit any questions that they have. Barbara, if you just want to go over the resources, and we'll give people another minute.
Sure. So again, you have our website and also our Facebook and Twitter handles there. The National Center for Homeless Ed, our wonderful, wonderful technical assistance clearinghouse by the U.S. Department of Education. Our partners, the National Network for Youth, are working specifically on unaccompanied homeless youth issues. And then we have some resources there for awareness raising that may be of interest to you, particularly as you look towards the fall. Real Students, Real Schools, and the McKinney-Vento Act in Our Schools, which is a great video that DVD that Patricia did. And then lastly, Hear Us, which has some good videos as well that can be helpful for awareness raising, sensitivity, things you might want to build into next year's professional development.
Thanks, Barbara. Maybe just one other question related to the eliminating barriers related to absences. I went over that slide pretty quickly and probably should have spent a little more time on it. Eliminating barriers related to absences, I think refers to many things, but maybe the most common would be there are sometimes high school programs that have zero tolerance policies where, for example, if a student has missed 10 days of school that semester, they can't enroll. They have to come back the following semester, the following year. Those kinds of policies obviously would need to be waived for McKinney-Vento students because they are barriers to immediate enrollment for those students. So that is something that I think really has always been included in the barrier removal language, but now it's specifically in there. There's also a kind of a process question for you, Barbara. Do we know when it is anticipated that the Department of Education will provide their guidance on McKinney-Vento under ESSA?
What we've been told is that the first guidance the department will issue will actually be on foster care. We've been told that that will be issued in June. So that again is guidance. It's not the same as regulations. It's supposed to be joint guidance from the Department of Ed and Department of Health and Human Services. So we'll see if that happens in June. In terms of McKinney-Vento, I am now hearing August. We had thought maybe it might be earlier. I don't know if that will be true or not, but certainly the department is planning on issuing its guidance prior to the effective date, which may seem like a no-brainer, but it actually didn't happen last time. Last time McKinney-Vento went effect in 2002, we didn't have guidance until 2 years later. So I do think that the guidance will be out before October 1st, and hopefully it'll be this summer.
Okay, that's great. Thanks, Barbara. I think at this point we've addressed really most of the questions that have come in through the chat box. If I've missed anything, because the conversation got very busy, which is wonderful, so there may be something up top that I've accidentally skipped over, so please feel free to email us at any time with any questions that you have. If we missed them on the webinar, if they just come to you later, we're always available to try to help you, particularly since we've got a big new law to try to figure out together. We're happy to help however we can. But I think
And
that concludes our questions, Barbara.
thanks, everybody. Sorry for the quick thing. I was just running through the slides to see if our email addresses were handy, but they're on the very first slide. You'll have our email addresses. And again, we're very happy to continue to work with you as we embark on this new ESSA era. So thanks very much.
Thanks, everyone. Bye.